MN Real Estate Exam Prep. Question 1. A broker compares a buyer's desired use with zoning rules, parcel size, and market demand. What appraisal principle is being considered for Quinn and Stillwater involving a condominium unit priced at $362,000? Option A, highest and best use. Option B, tie-in arrangement. Option C, novation. Option D, steering. The correct answer is option A, highest and best use. Highest and best use evaluates legal permissibility, physical possibility, financial feasibility, and maximum productivity. Tie-in arrangements, novation, and steering involve antitrust, contract substitution, and fair housing concerns. The analysis is about the most supportable property use. Question 2. When Jordan Davis buys a condominium unit in Edina, what does the buyer typically own? Option A, only a stock certificate and no real property interest. Option B, the individual unit plus an undivided interest in the common elements. Option C, the entire building in severalty. Option D, a temporary license to occupy the unit. The correct answer is option B, the individual unit plus an undivided interest in the common elements. Condominium ownership generally includes the individual unit and an undivided interest in common elements. A cooperative usually involves shares and a proprietary lease, not condominium ownership. The buyer does not own the whole building alone or merely hold a temporary license. Question 3. A title search finds an unpaid mechanics lien recorded against a Northfield property. Why does this matter to a buyer? Option A, it proves the buyer has already paid cash. Option B, it automatically creates a condominium. Option C, it may be an encumbrance affecting title and closing requirements. Option D, it removes all property taxes. The correct answer is option C, it may be an encumbrance affecting title and closing requirements. A mechanics lien can encumber title and may need to be resolved before or at closing. It does not prove cash payment, create condominium ownership, or remove tax obligations. Title review identifies recorded claims that may affect ownership. Question 4. A lender offers Blair Lee a mortgage whose interest rate can change based on an index after an initial period. What type of loan is this? Option A, package mortgage only. Option B, open-end listing. Option C, graduated lease. Option D, adjustable rate mortgage. The correct answer is option D, adjustable rate mortgage. An adjustable rate mortgage has an interest rate that may change according to an index and loan terms. A package mortgage includes personal property, an open-end listing is not a standard listing type, and a graduated lease changes rent over time. The index-based interest change identifies the loan type. Question 5. A listing agreement for a Edina seller is missing a definite end date. Why is that a licensing problem? Option A, Minnesota listing agreements must include a definite expiration date. Option B, listing agreements are valid only if they renew forever. Option C, expiration dates are allowed only in commercial leases. Option D, the county recorder assigns the expiration date after closing. The correct answer is option A. Minnesota listing agreements must include a definite expiration date. Minnesota listing agreements must be written and include a definite expiration date. Automatic indefinite listings create consumer protection concerns and do not meet the required content rules. County recorders do not supply listing agreement expiration dates. Question 6. A buyer purchases a $382,500 property with an 80% loan. What is the approximate loan amount? Option A, $76,500. Option B, $306,000. Option C, $21,038. Option D, $5,750. The correct answer is option B, $306,000. Loan amount is found by multiplying the sale price by the loan-to-value percentage. Down payment is the remaining equity, commission is based on brokerage compensation, and annual tax is a government charge. The loan-to-value percentage controls the financing amount. Question 7. A buyer includes an inspection condition in a Blaine purchase agreement. What is the role of that contingency? Option A. It automatically transfers title to the buyer. Option B. It eliminates the need for earnest money accounting. Option C. It makes the buyer's duty to perform depend on the stated inspection condition being satisfied or waived. Option D. It makes the broker a home inspector. The correct answer is option C. It makes the buyer's duty to perform depend on the stated inspection condition being satisfied or waived. A contingency is a condition that must be satisfied, waived, or otherwise resolved for the contract obligations to proceed as written. It does not transfer title or remove trust accounting duties. The broker does not become the inspector merely because the contract contains an inspection contingency. Question 8. A legal description begins at a point of beginning and follows distances and directions around the boundary. Which system is used? Option A. Gross rent multiplier. Option B. Capitalization rate. Option C. Straight line depreciation. Option D. Metes and bounds. The correct answer is option D. Metes and bounds. Metes and bounds descriptions trace boundaries using distances, directions, and a point of beginning. GRM, cap rate, and depreciation are valuation concepts. The boundary walking format identifies the legal description method. Question 9. A buried heating oil tank is discovered during inspection of a townhome. Why is this important? Option A. Underground storage tanks can create environmental and cleanup concerns that may affect value and use. Option B. They automatically convert the property to personal property. Option C. They prove the deed is forged. Option D. They eliminate all mortgage requirements. The correct answer is option A. Underground storage tanks can create environmental and cleanup concerns that may affect value and use. Underground storage tanks may involve leaks, regulatory requirements, and cleanup costs, making them material environmental concerns. They do not convert real estate into personal property, prove deed fraud, or remove financing requirements. Environmental issues can affect value, marketability, and buyer decisions. Question 10. A buyer brings certified funds for price, closing costs, and prepaid items after lender credits are applied. What is this amount commonly called? Option A. Gross rent multiplier. Option B. Cash to close. Option C. Functional obsolescence. Option D. Protective list. The correct answer is option B. Cash to close. Cash to close is the amount the buyer must bring to complete the transaction after credits, loan proceeds, and closing charges are calculated. GRM is an appraisal shortcut, functional obsolescence is depreciation, and a protective list relates to override clauses. The question is about closing settlement funds. Question 11. A licensee in Red Wing drafts a complex legal clause for Riley Chen instead of recommending legal counsel. What risk is created? Option A. Constructive eviction. Option B. Functional obsolescence. Option C. Unauthorized practice of law. Option D. Inverse condemnation. The correct answer is option C. Unauthorized practice of law. Licensees may fill in approved forms and explain business terms, but drafting legal clauses can cross into unauthorized practice of law. Constructive eviction, functional obsolescence, and inverse condemnation describe different legal or valuation issues. Complex legal drafting should be handled by an attorney. Question 12. If Drew passes the salesperson examination on a spring test date, how long does the candidate generally have to apply for the license before retaking the exam is required? Option A. 30 days from passing the examination. Option B. 3 years from passing the examination. Option C. Until the next broker renewal cycle only. Option D. 1 year from passing the examination. The correct answer is option D. 1 year from passing the examination. Minnesota guidance states that the salesperson license application must be made within 1 year after passing the examination. Shorter periods such as 30 days are too restrictive, and longer periods ignore the retake requirement. The broker renewal cycle does not control the candidate's examination validity period. Question 13. Before advertising Jordan Anderson's newly built townhouse to the general public, what must a Minnesota licensee obtain? Option A. A signed listing agreement or other signed written authorization from the owner or authorized person. Option B. An oral promise that the owner may list later. Option C. A buyer's pre-approval letter. Option D. A tax parcel map from the county. The correct answer is option A. A signed listing agreement or other signed written authorization from the owner or authorized person. A licensee must have a signed listing agreement or other signed written authorization before advertising real property for sale or lease to the general public. Oral permission is not enough for this requirement. Buyer pre-approval and tax maps may be useful, but they do not authorize public advertising. Question 14. In a dual agency situation in Maple Grove, why must the licensee avoid advocating exclusively for one party? Option A. The broker becomes a government mediator. Option B. The broker owes duties to both buyer and seller within the limits of dual agency. Option C. The buyer automatically becomes the broker's only client. Option D. The seller's broker relationship disappears at acceptance. The correct answer is option B. The broker owes duties to both buyer and seller within the limits of dual agency. Dual agency means the broker owes duties to both sides and must work within those limits. The broker is not converted into a government mediator, and neither party becomes the only client. Acceptance of an offer does not eliminate the agency relationship or the disclosure limits. Question 15. A property loses value because its floor plan is outdated compared with modern buyer expectations. What type of depreciation is most likely? Option A. Accretion. Option B. Economic rent. Option C. Functional obsolescence. Option D. Constructive notice. The correct answer is option C. Functional obsolescence. Functional obsolescence is loss in value from outdated design, layout, or utility within the property. Accretion is land buildup, economic rent is market rent, and constructive notice comes from public records. The problem is the property's function. Question 16. When Skylar, a licensee, intends to buy a client's property in Blaine, what disclosure is required before negotiation or consummation? Option A. The licensee may stay silent if paying full market value. Option B. The disclosure is needed only after the deed is recorded. Option C. Only the buyer's lender must be told about the license. Option D. The licensee must affirmatively disclose the license status and the capacity in which the licensee is acting. The correct answer is option D. The licensee must affirmatively disclose the license status and the capacity in which the licensee is acting. A Minnesota licensee who acquires or intends to acquire an interest in real property must disclose the license status and capacity before negotiation or consummation. Paying market value does not remove the conflict risk, and post-recording disclosure would be too late. Lender-only notice does not satisfy disclosure to the property owner. Question 17. At the end of a Minnesota tenancy, what must a landlord generally do with the tenant's security deposit after receiving a forwarding address for Sawyer in Northfield involving a duplex priced at $389,000? Option A. Return the deposit plus interest or provide a written explanation of lawful deductions within the required time. Option B. Keep the entire deposit automatically as a cleaning fee. Option C. Apply the deposit to the broker's commission. Option D. Record the deposit with the county as a deed restriction. The correct answer is option A. Return the deposit plus interest or provide a written explanation of lawful deductions within the required time. Minnesota law requires the landlord to return the deposit with interest or provide a written explanation for lawful deductions within the required period. Automatic forfeiture, commission payment, and county deed restrictions do not match the security deposit rules. Security deposits remain tenant funds unless a lawful deduction applies. Question 18. A deed expressly creates survivorship between co-owners of a townhome. Which ownership feature is being emphasized? Option A. No right to possess the property. Option B. Right of survivorship in joint tenancy. Option C. A tenant's trade fixture right. Option D. A mortgagee's foreclosure priority. The correct answer is option B. Right of survivorship in joint tenancy. Joint tenancy is associated with right of survivorship when properly created. Co-owners generally have possession rights, and trade fixtures concern tenants rather than co-owner succession. Mortgage priority is a lien issue, not survivorship ownership. Question 19. Which event usually allows trust funds in a Minnesota real estate transaction to be disbursed for Sawyer in Northfield involving a rental house priced at $276,000? Option A. A verbal request from one salesperson. Option B. A social media announcement that the deal is done. Option C. Closing of the transaction, written agreement of the parties, statutory affidavit, or court order. Option D. The buyers hope to renegotiate after closing. The correct answer is option C. Closing of the transaction, written agreement of the parties, statutory affidavit, or court order. Trust funds may be disbursed only under recognized authority such as closing, written agreement, applicable statutory affidavit, or court order. A verbal request or social media post does not provide the necessary authority. A buyer's later wish to renegotiate is not a trust fund disbursement event. Question 20. An older commercial building in Winona may contain asbestos insulation. What should the licensee avoid doing? Option A. Recommending qualified inspection or environmental advice. Option B. Disclosing known material facts. Option C. Using written reports from qualified professionals. Option D. Giving a technical safety opinion beyond the licensee's expertise. The correct answer is option D. Giving a technical safety opinion beyond the licensee's expertise. Asbestos concerns should be handled with qualified inspection and proper disclosure of known material facts. A licensee should avoid technical safety opinions outside the real estate role. Professional reports and disclosure are safer than speculation. Question 21. A mortgage contains a clause allowing the lender to call the full balance due after default. What clause is this for Rowan in Minneapolis involving a mixed-use property priced at $201,000? Option A. Acceleration clause. Option B. Habendum clause. Option C. Quiet enjoyment clause. Option D. Substitution clause in appraisal. The correct answer is option A. Acceleration clause. An acceleration clause allows the lender to demand the entire debt after default. A habendum clause is associated with deeds, quiet enjoyment appears in leases, and substitution in appraisal is a valuation principle. The trigger is borrower default. Question 22. A rumor says a Stillwater home was once the site of a natural death and possible paranormal activity. Under Minnesota disclosure rules, how is that fact treated? Option A. It must always be disclosed in the listing contract. Option B. It is not treated as a material fact that must be disclosed merely for that reason. Option C. It makes the property unmarketable until court approval. Option D. It requires the buyer to receive a separate environmental report. The correct answer is option B. It is not treated as a material fact that must be disclosed merely for that reason. Minnesota law states that certain stigmatizing facts, such as suicide, natural death, or perceived paranormal activity, are not material facts requiring disclosure merely because they occurred. That does not change the duty to disclose physical defects or other material facts. Listing contracts, court approval, and environmental reports address different issues. Question 23. Regarding commission language in a Minnesota listing agreement, which statement best reflects the required consumer notice for Avery in Maple Grove involving a fourplex priced at $470,500? Option A. The state sets one mandatory commission rate for all residential listings. Option B. The MLS sets the minimum commission for every listing. Option C. Compensation is determined between each individual broker and the broker's client. Option D. The buyer must always pay the listing broker directly. The correct answer is option C. Compensation is determined between each individual broker and the broker's client. Minnesota listing agreements must include a notice that compensation is determined between the broker and the broker's client. The state and MLS do not set a universal commission rate for every transaction. Payment arrangements depend on the agreement and cannot be assumed from the listing alone. Question 24. Under Chapter 82 standards, What must a broker do to properly supervise salespersons at a Blaine office? Option A. Let each salesperson approve their own contracts without broker review. Option B. Delegate all trust records to buyers and sellers. Option C. Supervise only advertising and ignore purchase agreements. Option D. Monitor brokerage activities, review transaction documents, and review trust account books and records. The correct answer is option D. Monitor brokerage activities, review transaction documents, and review trust account books and records. Broker supervision includes ongoing monitoring of salespersons, transaction documents, and trust account records. Salespersons do not self-supervise, and clients are not responsible for brokerage trust accounting. Limiting supervision to advertising would miss major broker responsibilities. Question 25. Why is the Minnesota agency disclosure form given to Emerson Johnson not enough by itself to create representation? Option A. It is a disclosure only, and representation requires a written listing contract or buyer representation contract. Option B. It automatically creates dual agency for every transaction. Option C. It replaces all purchase agreement requirements. Option D. It gives the consumer a license to sell property. The correct answer is option A. It is a disclosure only, and representation requires a written listing contract or buyer representation contract. The agency disclosure form informs consumers about relationship options but does not create representation. Representation requires a written contract such as a listing agreement or buyer representation contract. The other choices confuse disclosure with dual agency, purchase contracts, or licensing authority. Question 26. A buyer credit on a closing statement for assumed unpaid taxes generally does what? Option A. Increases the seller's loan payoff. Option B. Reduces the buyer's cash needed because the buyer will later pay the tax bill. Option C. Eliminates title insurance. Option D. Creates a new listing agreement. The correct answer is option B. Reduces the buyer's cash needed because the buyer will later pay the tax bill. A buyer credit reduces cash due from the buyer when the buyer assumes a future obligation connected to the seller's ownership period. Loan payoff, title insurance, and listing agreements are separate closing or contract issues. Credits and debits must be read from the party's perspective. Question 27. At closing, why are prepaid property taxes or rents commonly prorated between buyer and seller for Schuyler in Rochester involving a small retail building priced at $250,000? Option A. To change the sales price after acceptance. Option B. To avoid recording the deed. Option C. To allocate income or expenses to the party who owned the property during the relevant time period. Option D. To eliminate the need for title insurance. The correct answer is option C. To allocate income or expenses to the party who owned the property during the relevant time period. Priorations allocate recurring income and expenses based on the period each party is entitled to or responsible for them. They do not rewrite the price, avoid recording, or replace title insurance. Closing statements use debits and credits to make this allocation. Question 28. Under federal fair housing law, which group is a protected class in the sale or rental of housing for Kendall and Egan involving a small retail building priced at $391,000? Option A. Credit score above 700. Option B. Preference for lakefront homes. Option C. Employment in real estate sales. Option D. Familial status. The correct answer is option D. Familial status. Familial status is a protected class under federal fair housing law. Credit score, housing preferences, and occupation in real estate are not protected classes by themselves. Housing decisions must avoid discrimination based on protected characteristics. Question 29. A legal description refers to township, range, and section. Which survey system is being used? Option A. Rectangular government survey system. Option B. Meets and bounds only. Option C. Lot and block only. Option D. A gross lease system. The correct answer is option A. Rectangular government survey system. The rectangular government survey system uses townships, ranges, and sections. Meets and bounds relies on boundary calls, and lot and block relies on subdivision plats. Gross lease is a lease structure, not a land description system. Question 30. If one broker represents both Sawyer Wilson and Drew Miller in a residential transaction, what must occur before the broker acts as a dual agent? Option A. Only the seller must consent because the seller listed the property. Option B. All parties must give informed consent to the dual agency relationship. Option C. The broker may proceed without consent if the commission is reduced. Option D. Consent is unnecessary if two different salespersons are involved. The correct answer is option B. All parties must give informed consent to the dual agency relationship. Dual agency requires informed consent from the parties because the broker owes duties to both sides and cannot advocate exclusively for either one. A lower commission does not remove the conflict, and two salespersons licensed to the same broker can still create dual agency. Seller-only consent is not enough. Question 31. If a seller rejects Cameron Okafor's offer and the listing broker holds the earnest money, when should the rejected offer's earnest money be returned? Option A. Only after the seller signs a different purchase agreement. Option B. At the end of the listing period. Option C. No later than the next business day after rejection. Option D. After the broker deducts marketing expenses. The correct answer is option C. No later than the next business day after rejection. When an offer is rejected, Minnesota trust account rules require earnest money to be returned to the potential buyer no later than the next business day after rejection. The broker cannot hold it until another sale, listing expiration, or reimbursement of marketing costs. Rejected offers do not create a right to keep the buyer's funds. Question 32. A Minnesota landlord withholds a deposit for faded paint caused by normal use. Why is that deduction questionable for Cameron in St. Paul involving a rental house priced at $312,500? Option A. Deposits may be withheld only for broker commissions. Option B. All paint changes are automatically tenant damage. Option C. The tenant must buy the property to get the deposit back. Option D. Normal wear and tear is not a proper basis for withholding a security deposit. The correct answer is option D. Normal wear and tear is not a proper basis for withholding a security deposit. Security deposit deductions are for items such as unpaid rent or damage beyond ordinary wear and tear. Normal fading from ordinary use is not the same as tenant-caused damage. Broker commissions and purchase rights are unrelated to residential deposit accounting. Question 33. Why might Sawyer Johnson use a quitclaim deed to clear a possible title issue? Option A. It transfers whatever interest the grantor may have without making title warranties. Option B. It guarantees the property is free of every lien. Option C. It creates a new mortgage automatically. Option D. It replaces the need for delivery and acceptance. The correct answer is option A. It transfers whatever interest the grantor may have without making title warranties. A quitclaim deed can release or transfer any interest the grantor may have, but it does not warrant title quality. It does not guarantee lien-free ownership or create a mortgage. Like other deeds, it still depends on proper execution, delivery, and acceptance. Question 34. A loan payment schedule gradually reduces principal until the loan balance reaches zero. What financing term describes this for Reese and Red Wing involving a single-family home priced at $380,000? Option A. Accretion. Option B. Amortization. Option C. Subordination. Option D. This cheat. The correct answer is option B. Amortization. Amortization is repayment of a debt through payments that reduce principal over time. Accretion is natural land buildup. Subordination changes lien priority, and escheat transfers property to the state when no heirs exist. The decreasing loan balance is the clue. Question 35. A homestead classification question appears on a Minnesota practice exam. What topic is being tested most directly? Option A. Federal lead paint pamphlet rules only. Option B. Advertising font size only. Option C. A property tax and ownership status treatment. Option D. Dual agency consent wording only. The correct answer is option C, property tax and ownership status treatment. Homestead classification generally relates to property tax and ownership or occupancy status. Lead paint, advertising, and dual agency are separate real estate topics. Exam questions may connect homestead status with tax treatment and ownership rights. Question 36. While interviewing with two firms in Bloomington, Casey asks how many Minnesota brokers may supervise the salesperson during the same period. Option A, 2 brokers if both brokers consent. Option B, any number of brokers if the salesperson discloses the arrangement. Option C, 1 broker for residential sales and a separate broker for leases. Option D, 1 actively licensed broker. The correct answer is option D, 1 actively licensed broker. A salesperson in Minnesota is licensed to act on behalf of 1 broker during the same period. Consent or disclosure does not create authority to work under multiple brokers. Splitting residential and leasing work between brokers would still violate the Single Broker Association rule. Question 37. At Prairie Realty, a salesperson asks which online system the Commerce Department uses for many licensing services such as applications, renewals, and transfers. Option A, Pulse. Option B, MLS Grid. Option C, Torrens Online. Option D, HUD Exchange. The correct answer is option A, Pulse. Pulse is the electronic licensing system used for many Minnesota Commerce Department licensing services. MLS systems, Torrens records, and HUD resources serve different purposes. Knowing the licensing portal helps distinguish administrative filing from transaction records and federal housing resources. Question 38. A city special assessment for a new sidewalk appears on a property record. What kind of charge is it most like? Option A, a private broker commission split. Option B, a charge against benefited property for a public improvement. Option C, a personal credit card debt. Option D, a title insurance premium refund. The correct answer is option B, a charge against benefited property for a public improvement. A special assessment is commonly charged against properties that benefit from a public improvement. It is not a broker split, personal consumer debt, or title insurance refund. Assessments can affect closing and ownership costs. Question 39. In appraisal, what does highest and best use require for Morgan in Winona involving a townhome priced at $385,000? Option A, the use that produces the highest commission. Option B, the use preferred by the current tenant only. Option C, a use that is legally permissible, physically possible, financially feasible, and maximally productive. Option D, the use with the lowest property tax bill. The correct answer is option C, a use that is legally permissible, physically possible, financially feasible, and maximally productive. Highest and best use considers legal, physical, financial, and productivity tests. Commission, tenant preference, and tax savings alone do not determine highest and best use. The concept focuses on the most supportable use of the property as real estate. Question 40. A tenant with a disability asks for an assigned accessible parking space near the entrance. What fair housing concept is most directly involved for Drew in Mankato involving a single-family home priced at $361,000? Option A, adverse possession. Option B, yield spread premium. Option C, defeasance clause. Option D, reasonable accommodation. The correct answer is option D, reasonable accommodation. A reasonable accommodation is a change in rules, policies, or services that may be needed for a person with a disability to use and enjoy housing. Adverse possession concerns ownership claims, yield spread premiums concern loan compensation, and defeasance clauses concern loan satisfaction. The requested parking change involves access to housing. Question 41. Recording a deed for a rental house in Stearns County primarily gives what type of notice to the public? Option A, constructive notice. Option B, private notice only to the buyer's lender. Option C, a zoning variance. Option D, a guarantee of physical condition. The correct answer is option A, constructive notice. Recording places an instrument in the public records and gives constructive notice of the recorded interest. It does not create a zoning variance or guarantee the property's physical condition. The public records system protects priority and notice, not building quality. Question 42. A deed is signed by the grantor but never delivered to Quinley. Why is delivery important? Option A. Delivery sets the mortgage interest rate. Option B. Delivery shows the grantor's intent that the deed take effect. Option C. Delivery replaces legal description requirements. Option D. Delivery creates a leasehold only. The correct answer is option B. Delivery shows the grantor's intent that the deed take effect. A deed must be delivered and accepted to operate as a conveyance. Delivery reflects the grantor's intent that the instrument take effect. It does not set loan terms, replace the legal description, or create only a leasehold. Question 43. A buyer takes title while the seller's existing loan remains in place, but the buyer does not become personally liable to the lender. What phrase best describes this for Schuyler and Rochester involving a small retail building priced at $319,500? Option A. Assuming the mortgage with release. Option B. Creating a life estate. Option C. Taking subject to the mortgage. Option D. Recording a quitclaim covenant. The correct answer is option C. Taking subject to the mortgage. Taking subject to a mortgage means the property remains security for the debt, but the buyer does not personally promise the lender to pay. Assumption involves personal liability unless otherwise released. Life estates and quitclaim covenants are unrelated to this financing arrangement. Question 44. A legal description identifies a lot and block in a recorded subdivision plat. Which description method is used? Option A. Rectangular survey only. Option B. Monumentless description. Option C. Front foot appraisal. Option D. Lot and block. The correct answer is option D. Lot and block. Lot and block descriptions rely on a recorded subdivision plat. Rectangular survey uses sections, townships, and ranges, while front foot appraisal values frontage. The presence of a recorded plat points to lot and block. Question 45. Before Parker schedules the salesperson examination after studying in Winona, which pre-license course must already be completed? Option A. Course I. Option B. Course 2 only. Option C. Course 3 only. Option D. The annual continuing education module. The correct answer is option A. Course I. Course I must be successfully completed before a candidate registers for the salesperson examination. Course 2 and Course 3 are required before license application, while the annual module is a continuing education requirement for licensees. Confusing pre-license and continuing education rules leads to the wrong result. Question 46. If a Bemidji property sells for $285,000 and the buyer obtains an 75% loan, what is the buyer's down payment? Option A. $213,750. Option B. $71,250. Option C. $15,675. Option D. $1,808. The correct answer is option B. $71,250. The down payment is the sale price minus the loan amount. The loan amount is the financed portion, the commission is a brokerage compensation calculation, and the tax proration allocates property taxes. Separating buyer equity from loan proceeds is a core exam math skill. Question 47. An advertisement says a condominium unit is available only for adults with no children. What is the main fair housing concern? Option A. The ad forgot to mention the roof age. Option B. The ad uses a list price instead of an appraised value. Option C. The statement indicates a preference or limitation based on familial status. Option D. The ad includes the city name. The correct answer is option C. The statement indicates a preference or limitation based on familial status. Advertising cannot indicate a discriminatory preference or limitation based on familial status except where a valid housing for older persons exemption applies. Roof age, list price, and city name are not the fair housing issue in the wording. The problem is discouraging families with children. Question 48. A deed gives Hayden possession for life, then ownership passes to Morgan Peterson. What interest does Morgan Peterson hold before Hayden's death? Option A, leasehold estate. Option B, easement in gross. Option C, mortgage lien. Option D, a remainder interest. The correct answer is option D, remainder interest. A remainder interest is a future interest that becomes possessory after a life estate ends. A leasehold is a tenant's possession, an easement in gross is a use right, and a mortgage lien secures debt. The buyer's right follows the life tenant's measuring life. Question 49. A buyer agrees with the lender to become personally liable on the seller's existing mortgage. What is the buyer doing for Casey and Bemidji involving a condominium unit priced at $328,500? Option A, assuming the mortgage. Option B, taking subject to the mortgage only. Option C, creating an easement appurtenant. Option D, paying deed tax only. The correct answer is option A, assuming the mortgage. Mortgage assumption involves the buyer taking personal responsibility for the existing loan obligation with lender involvement. Taking subject to a mortgage lacks personal liability to the lender. Easements and deed taxes do not describe assuming debt. Question 50. A seller says the basement is perfectly dry despite knowing of repeated water intrusion. Why is that more than ordinary puffing for Reese and Red Wing involving a single-family home priced at $399,500? Option A. It is always protected opinion regardless of knowledge. Option B. It is a factual misrepresentation about a material property condition. Option C. It is allowed if the buyer gets a loan. Option D. It becomes legal if stated verbally instead of in writing. The correct answer is option B. It is a factual misrepresentation about a material property condition. A specific false statement about a known material condition can be misrepresentation. Puffing is general opinion, not a false factual claim about water problems. Financing approval or verbal delivery does not make a known material misstatement acceptable. Question 51. A $448,000 sale carries a 6% commission. What is the total commission before any split? Option A, $89,600. Option B, $3,584. Option C, $26,880. Option D, $8,870. The correct answer is option C, $26,880. Total commission is found by multiplying the sale price by the commission rate. Down payment, discount points, and property tax calculations use different bases. The phrase before any split means the full brokerage commission is calculated first. Question 52. If an override clause appears in Casey Miller's listing agreement, what must the licensee provide within 72 hours after the listing expires for the clause to be effective? Option A, a new deed. Option B, a county tax appeal. Option C, a mortgage payoff statement. Option D, a protective list. The correct answer is option D, a protective list. An override clause is tied to a protective list supplied within the required time after expiration. A deed, tax appeal, or payoff statement does not preserve the broker's override rights. The protective list identifies prospects covered by the clause. Question 53. A facilitator working with Sawyer in Maple Grove performs services without representing either side. Which fiduciary duty generally remains unless expanded by written agreement? Option A, confidentiality. Option B, loyalty to the seller only. Option C, obedience to the buyer's investment goals. Option D, advocacy for the party paying the commission. The correct answer is option A, confidentiality. A facilitator does not act in a fiduciary capacity as a buyer's broker, seller's broker, or dual agent, but confidentiality remains a duty unless the relationship is expanded by written agreement. Loyalty, obedience, and advocacy belong to agency representation, not ordinary facilitator status. Commission payment does not create fiduciary representation by itself. Question 54. In Moorhead, A new applicant asks which combination best describes the salesperson licensing path in Minnesota. Option A. Be at least 21, complete only course I, and work independently after passing the exam. Option B. Be at least 18, complete courses 1, 2, and 3, pass the exam, associate with a broker, and receive Commerce Department approval. Option C. Complete continuing education before any pre-license education and apply directly without a broker. Option D. Pass only the national exam and begin practicing while the application is pending. The correct answer is option B. Be at least 18, complete courses 1, 2, and 3, pass the exam, associate with a broker, and receive Commerce Department approval. Minnesota salesperson licensing requires age eligibility, 3 30-hour pre-license courses, examination success, broker association, and approval by the Commerce Department. The other choices either remove required courses, allow independent practice, or treat a pending application as authority to act. Those alternatives do not satisfy the licensing sequence. Question 55. A borrower gives a mortgage on a Winona property while retaining possession. What financing concept lets the borrower pledge the property without surrendering it? Option A. Avulsion. Option B. Emblements. Option C. Hypothecation. Option D. Accession. The correct answer is option C. Hypothecation. Hypothecation means pledging property as security for a debt while retaining possession. Avulsion and accession concern land or property changes, while emblements are crops. Mortgage lending commonly uses hypothecation. Question 56. A factory closure outside the neighborhood reduces demand for nearby homes. What type of depreciation does this suggest for Schuyler in Rochester involving a townhome priced at $283,500? Option A. Physical deterioration only. Option B. A functional obsolescence only. Option C. Accession. Option D. External obsolescence. The correct answer is option D. External obsolescence. External obsolescence is value loss caused by factors outside the property, such as economic changes or adverse surroundings. Physical deterioration is wear and tear, while functional obsolescence is internal design deficiency. A factory closure is external to the property. Question 57. A Woodbury parcel contains 5 acres. How many square feet are in the parcel? Option A. 217,800. Option B. $8,000. Option C. $242,550. Option D. $4,743. The correct answer is option A. 217,800. 1 acre contains 43,560 square feet, so acreage is converted by multiplying acres by 43,560. Frontage value, loan amount, and tax amount are calculated from different data. Unit conversion is a common real estate math task. Question 58. For a pre-1978 residential property, what federal disclosure issue should a licensee remember for Taylor and Moorhead involving a duplex priced at $460,500? Option A. The property can never be sold. Option B. Lead-based paint disclosure requirements may apply before the buyer or tenant is obligated. Option C. Only commercial buyers receive the pamphlet. Option D. Lead disclosure replaces all agency disclosure. The correct answer is option B. Lead-based paint disclosure requirements may apply before the buyer or tenant is obligated. Federal lead-based paint rules apply to many pre-1978 residential transactions and require disclosure before the buyer or tenant is obligated. The rules do not ban every sale or limit disclosure to commercial buyers. Lead disclosure is separate from agency disclosure and material fact duties. Question 59. A salesperson tells owners in Blaine to sell quickly because people from a protected class are moving nearby. What prohibited practice does this describe? Option A. Reconciliation. Option B. Hypothecation. Option C. Blockbusting. Option D. Assemblage. The correct answer is option C. Blockbusting. Blockbusting uses fear or panic about protected class changes to induce owners to sell or rent. Reconciliation is an appraisal step. Hypothecation pledges property as loan security, and assemblage combines parcels. The key issue is discriminatory pressure on owners. Question 60. Under Minnesota licensing rules, what happens when a salesperson's association with an actively licensed broker ends for Parker and Brainerd involving a townhome priced at $475,000? Option A. The salesperson may continue independently for 90 days. Option B. The salesperson automatically becomes a limited broker. Option C. The salesperson may transfer clients without broker supervision. Option D. The salesperson's license becomes inactive until proper association is restored. The correct answer is option D. The salesperson's license becomes inactive until proper association is restored. A salesperson license depends on active association with a licensed broker. Ending that association makes the license inactive, so independent practice is not allowed. Automatic broker status and unsupervised client transfers are not part of the salesperson licensing structure. Question 61. Which appraisal approach is usually most persuasive for a typical owner-occupied home in a subdivision with many recent comparable sales for Morgan and Winona involving a newly built townhouse priced at $271,000? Option A. Sales comparison approach. Option B. Cost approach only. Option C. Income approach only. Option D. Front foot method only. The correct answer is option A. Sales comparison approach. The sales comparison approach is usually strongest when similar properties have sold recently in the same market. The cost approach can be useful for new or special purpose improvements, and the income approach is more relevant to income-producing property. Front foot analysis is a land valuation tool, not the main method for a typical home. Question 62. In a lien theory mortgage state such as Minnesota, what does the mortgage usually give the lender for Blair in Duluth involving a condominium unit priced at $197,500? Option A. Immediate ownership and possession of the property. Option B. A lien securing repayment while the borrower retains title. Option C. A life estate measured by the borrower's life. Option D. A leasehold estate for the loan term. The correct answer is option B. A lien securing repayment while the borrower retains title. In lien theory, the mortgage gives the lender a security lien rather than immediate title and possession. The borrower retains legal title unless foreclosure changes ownership. Life estates and leaseholds are different interests, not the ordinary mortgage relationship. Question 63. An appraiser adjusts comparable sales for differences from the subject property. Which approach is being applied for Jordan and Woodbury involving a mixed-use property priced at $193,500? Option A. Cost approach only. Option B. Income approach only. Option C. Sales comparison approach. Option D. Mortgage registry method. The correct answer is option C. Sales comparison approach. The sales comparison approach compares the subject to similar sold properties and adjusts for differences. Cost and income approaches use different inputs, and mortgage registry tax is not an appraisal method. Comparable sale adjustment is a core valuation technique. Question 64. Which Minnesota tax is generally associated with recording a mortgage that secures debt on real property for Cameron in St. Paul involving a rental house priced at $344,500? Option A. Personal income withholding tax. Option B. Sales tax on furniture. Option C. Special assessment appeal fee. Option D. Mortgage registry tax. The correct answer is option D. Mortgage registry tax. Mortgage registry tax is tied to the recording of a mortgage securing debt. Personal income withholding, furniture sales tax, and assessment appeals are different issues. The exam often distinguishes mortgage registry tax from deed tax. Question 65. What is the main purpose of an owner's title insurance policy for Emerson Johnson? Option A. To protect against covered title defects that existed before the policy date. Option B. To insure the roof against storm damage. Option C. To guarantee future market appreciation. Option D. To replace the need for a purchase agreement. The correct answer is option A. To protect against covered title defects that existed before the policy date. Owner's title insurance protects against covered past title defects, liens, or ownership issues discovered after closing. It is not property casualty insurance, an appreciation guarantee, or a substitute for the purchase contract. Title insurance focuses on ownership risk, not physical damage or investment performance. Question 66. If annual property taxes of $4,750 are prorated to the seller for 68 days on a 365-day basis, approximately what amount is charged to the seller? Option A, $13,375. Option B, $885. Option C, $2,728. Option D, $910. The correct answer is option B, $885. Tax proration divides the annual tax by 365 and multiplies by the number of seller days. Commission, discount points, and monthly interest are unrelated calculations. Proration allocates an annual expense fairly between buyer and seller at closing. Question 67. If assessed value is $283,500 and the tax rate is 18 mils, what is the annual property tax? Option A, $1,230. Option B, $7,088. Option C, $5,103. Option D, $78,750. The correct answer is option C, $5,103. A mil is $1 per $1,000 of assessed value, so the tax is assessed value multiplied by mils divided by 1,000. Monthly interest, points, and down payment are financing calculations. Millage questions require converting mils to a decimal rate. Question 68. A buyer asks about radon during a Eden Prairie home purchase. What is the safest professional response for a licensee? Option A, guarantee that radon is never a concern in Minnesota. Option B, tell the buyer to ignore radon because it is a title defect. Option C, prepare a scientific certification without testing. Option D, provide required or available radon information and recommend appropriate testing or qualified advice rather than guaranteeing levels. The correct answer is option D. Provide required or available radon information and recommend appropriate testing or qualified advice rather than guaranteeing levels. Radon is an environmental concern that should be addressed with required information, testing, and qualified resources. A licensee should not guarantee levels or provide scientific certification without proper expertise. Radon is a physical/environmental issue, not a title defect. Question 69. A neighbor receives permission to park on Rowan Okafor's land for one weekend only. What interest is most likely created? Option A, license. Option B, easement appurtenant. Option C, fee simple estate. Option D, a mechanic's lien. The correct answer is option A, license. A license is personal permission to use property and is generally revocable. An easement appurtenant is a more durable interest tied to benefited land, fee simple is ownership, and a mechanic's lien secures payment. Temporary parking permission is a license. Question 70. A St. Cloud salesperson wants to place personal money in the broker trust account to save for taxes. Why is that improper? Option A, personal funds must always be kept in the listing broker's trust account. Option B, trust accounts may contain only trust funds except limited identified funds for service charges or minimum balance requirements. Option C, salespersons may use trust accounts as savings accounts with broker consent. Option D, commingling is allowed when the amount is less than 1 month's rent. The correct answer is option B. Trust accounts may contain only trust funds except limited identified funds for service charges or minimum balance requirements. Trust accounts are for trust funds, with only limited identified personal funds allowed for service charges or minimum balance requirements. Using the account as a personal savings account would commingle funds. Broker consent or a small amount does not change the commingling rule. Question 71. A retail tenant pays base rent plus a percentage of monthly sales. What lease type is described for Hayden and Blaine involving a newly built townhouse priced at $224,500? Option A, ground lease only. Option B, graduated deed. Option C, percentage lease. Option D, quitclaim lease. The correct answer is option C, percentage lease. A percentage lease includes rent based partly on the tenant's sales, commonly in retail settings. A ground lease involves leasing land, and the other terms are not standard lease classifications. The sales volume rent formula is the key clue. Question 72. A rental property produces $44,500 in net operating income and investors require a 7.5% capitalization rate. What value is indicated by the income approach? Option A, $184,375. Option B, $156,100. Option C, $41,850. Option D, $593,333. The correct answer is option D, $593,333. The income approach using direct capitalization divides net operating income by the capitalization rate. Gross rent multiplier, loan amount, and frontage calculations use different inputs. The cap rate converts expected net income into an indicated value. Question 73. A utility company has the right to run power lines across a St. Cloud parcel. Which property right is usually involved? Option A, easement in gross. Option B, the state for years. Option C, devolution. Option D, a remainder interest. The correct answer is option A, easement in gross. A utility easement often benefits a company rather than a neighboring parcel, making it an easement in gross. An estate for years is a leasehold, avulsion is sudden land change, and a remainder follows a life estate. The utilities right is a non-possessory use right. Question 74. Why should a purchase agreement for a fourplex in St. Cloud be in writing and signed by the party to be charged? Option A. All oral contracts are criminal offenses. Option B. The statute of frauds requires most real estate sale contracts to be in writing to be enforceable. Option C. Only lenders may sign real estate contracts. Option D. A deed is unnecessary if the parties shake hands. The correct answer is option B. The statute of frauds requires most real estate sale contracts to be in writing to be enforceable. The statute of frauds generally requires contracts for the sale of real property to be in writing and signed by the party to be charged. Oral agreements may fail enforceability even if the parties intended a deal. Lender-only signatures and handshake transfers do not replace the required written contract and later conveyance documents. Question 75. A parcel borders a lake near Blaine. Rights associated with use of the lakeshore are commonly called what? Option A, riparian rights only. Option B, fixture rights. Option C, littoral rights. Option D, novation rights. The correct answer is option C, littoral rights. Littoral rights generally relate to property bordering lakes, seas, or oceans. Riparian rights involve rivers and streams. Fixtures concern attached property, and novation is contract substitution. The lakefront fact drives the answer. Question 76. A lender draws a line around a Beltrami neighborhood and refuses otherwise qualified mortgage applicants there. What fair housing and lending term best fits? Option A, plottage. Option B, accretion. Option C, estoppel. Option D, a redlining. The correct answer is option D, redlining. Redlining is denying or limiting credit in an area for discriminatory reasons rather than evaluating individual qualifications. Plottage relates to value from assemblage, accretion is natural land buildup, and estoppel prevents inconsistent claims. Area-based discriminatory lending violates fair lending principles. Question 77. A lender must disclose the cost of consumer credit so borrowers can compare loan terms. Which federal law is most directly involved for Quinn and Stillwater involving a condominium unit priced at $278,500? Option A, Truth in Lending Act. Option B, Sherman Antitrust Act only. Option C, Clean Water Act only. Option D, Minnesota Torrens Act only. The correct answer is option A. Truth in Lending Act. Truth in lending requires disclosure of credit terms such as APR in many consumer loans. Antitrust, environmental, and Torrens land registration laws address different areas. The question focuses on loan cost disclosure. Question 78. A parcel borders a non-navigable stream. Rights connected to that water are commonly called what? Option A. Literal rights only. Option B. Riparian rights. Option C. Emblement rights. Option D is subrogation rights. The correct answer is option B. Riparian rights. Riparian rights relate to land adjoining rivers or streams. Literal rights are associated with lakes and other large bodies of water, while emblements and subrogation are different concepts. Water-adjacent property rights are common ownership questions. Question 79. Why would an appraiser rely heavily on the cost approach for a newly built single-family home in Woodbury? Option A. It ignores land value completely. Option B. It is the only legal method for all residential property. Option C. Replacement cost and depreciation can be estimated more reliably for new improvements. Option D. It values the property only by monthly rent. The correct answer is option C. Replacement cost and depreciation can be estimated more reliably for new improvements. The cost approach is useful for new construction because replacement cost and accrued depreciation can be estimated with less uncertainty. It still includes land value and is not the only legal method for every property. Monthly rent belongs to income analysis rather than cost analysis. Question 80. During a Winona license renewal review, which continuing education schedule best matches Minnesota salesperson requirements? Option A. 10 hours every 4 years with no annual deadline. Option B. 30 hours only during the first licensing year. Option C. Only the required module with no other continuing education. Option D. 30 hours before the June 30th renewal deadline, with at least 15 hours completed before the previous June 30th. The correct answer is option D. 30 hours before the June 30th renewal deadline, with at least 15 hours completed before the previous June 30th. Minnesota salespersons generally need 30 hours of continuing education before the June 30th renewal deadline, with at least 15 hours due before the previous June 30th. The other options understate the hours, remove the annual structure, or treat the module as the only requirement. Continuing education must be completed in the proper license period. Question 81. Which deed gives Morgan Rivera the broadest set of title warranties from the grantor? Option A. General warranty deed. Option B. Quitclaim deed. Option C. Bargain and sale deed with no covenants. Option D. Tax certificate only. The correct answer is option A. General warranty deed. A general warranty deed provides the strongest customary covenants of title from the grantor. A quitclaim deed conveys whatever interest the grantor has without warranties. A bargain and sale deed without covenants and a tax certificate provide less assurance than a general warranty deed. Question 82. A property has monthly gross rent of $2,225 and sells for $267,000. What is the gross rent multiplier? Option A. 6.5%. Option B. 120.0. Option C. 6.5%. Option D. 90%. The correct answer is option B. 120.0. Gross rent multiplier is price divided by gross rent for the same period. Cap rate, commission rate, and loan-to-value percentage measure different relationships. GRM is a quick income property comparison tool, not a complete valuation method. Question 83. During negotiations in Maple Grove, Taylor Okafor changes the price and closing date in the seller's offer. What is the legal effect of that response? Option A. It is an acceptance because some terms stayed the same. Option B. It creates a lease instead of a purchase contract. Option C. It is a counteroffer that rejects the original offer and proposes new terms. Option D. It keeps the original offer open forever. The correct answer is option C. It is a counteroffer that rejects the original offer and proposes new terms. Changing material terms creates a counteroffer rather than an acceptance. The original offer is rejected unless the offeror renews or accepts the new terms. Keeping some terms unchanged does not preserve the original offer forever or convert the transaction into a lease. Question 84. A licensee directs families with children only toward one area of Rochester. What fair housing problem does that conduct create? Option A, amortization. Option B, subordination. Option C, novation. Option D, steering. The correct answer is option D, steering. Steering occurs when a real estate professional guides prospects toward or away from areas based on a protected characteristic. Amortization is loan repayment, subordination is lien priority adjustment, and novation is contract substitution. The conduct described limits housing choice and raises fair housing risk. Question 85. Wetlands are suspected on a vacant Winona County parcel. What should a licensee recommend before development assumptions are made? Option A, obtain qualified advice about wetland restrictions and permitting. Option B, assume all wetlands can be filled without approval. Option C, use only the buyer's preferred building sketch. Option D, ignore wetlands because they affect only personal property. The correct answer is option A, obtain qualified advice about wetland restrictions and permitting. Wetland restrictions can limit development and require permits or expert review. Assuming fill is allowed or relying only on a sketch creates risk. Wetlands are real property and land use issues, not merely personal property concerns. Question 86. An appraiser subtracts curable physical deterioration and functional obsolescence from replacement cost. Which approach is being used for Casey and Bemidji involving a vacant lot priced at $290,500? Option A, sales comparison approach only. Option B, cost approach. Option C, income approach only. Option D, gross rent multiplier only. The correct answer is option B, cost approach. The cost approach estimates land value plus improvement cost minus depreciation. Sales comparison relies on comparable sales, and income analysis capitalizes income. Depreciation from replacement cost is the clue. Question 87. A landlord receives a forwarding address after a tenant leaves a Minnesota rental. What deadline is commonly tested for returning the deposit or giving a written explanation for Sawyer in Northfield involving a fourplex priced at $201,500? Option A, within 1 year after the lease began. Option B, only at the next property tax settlement. Option C, within 21 days after the tenancy ends, assuming the forwarding address requirement is met. Option D, whenever the landlord sells the building. The correct answer is option C, within 21 days after the tenancy ends, assuming the forwarding address requirement is met. Minnesota landlord-tenant materials commonly test the 21-day security deposit return or explanation period after the tenancy ends and the forwarding address is provided. Waiting for a tax settlement, building sale, or 1-year mark does not match the standard rule. The landlord must account for the deposit promptly. Question 88. After passing the examination, Hayden wants to submit a Minnesota salesperson license application immediately. Which education requirement still must be met before applying? Option A, only course I is ever required for the license. Option B, a broker's 30-hour course must replace course 3. Option C, no additional education is needed once the exam is passed. Option D, courses 2 and 3 must be successfully completed if they have not already been completed. The correct answer is option D. Courses 2 and 3 must be successfully completed if they have not already been completed. Course I opens exam eligibility, but courses 2 and 3 must be completed before the salesperson license application. Passing the exam does not erase the remaining pre-license education requirement. The other options either omit required courses or invent a broker-only replacement course. Question 89. Unless the parties' written agreement says otherwise, when should a Minnesota listing broker deposit earnest money after receiving it and final acceptance has occurred for Drew in Mankato involving a lake cabin priced at $406,000? Option A, within 3 business days of receipt or final acceptance, whichever is later. Option B, only after the buyer's loan is fully underwritten. Option C. At any time before the deed is recorded. Option D. Within 30 calendar days after the first showing. The correct answer is option A. Within 3 business days of receipt or final acceptance, whichever is later. Minnesota trust account rules provide a default deadline of 3 business days after receipt or final acceptance, whichever is later, when the written agreement is silent. Waiting for underwriting, recording, or an arbitrary 30-day period would not meet that default rule. The parties can address timing in their written agreement. Question 90. A lender requires private mortgage insurance because Finley Lee's conventional loan has a high loan-to-value ratio. What does PMI primarily protect? Option A. The buyer against title defects. Option B. The lender against part of the risk of borrower default. Option C. The seller against market depreciation. Option D. The appraiser against negligence claims. The correct answer is option B. The lender against part of the risk of borrower default. Private mortgage insurance protects the lender when a conventional loan has higher default risk due to low borrower equity. It does not protect the buyer's title, guarantee the seller's price, or insure an appraiser's liability. Borrowers often pay for PMI, but the lender is the protected party. Question 91. If Reese Garcia pays interest only for the first month on a $267,000 loan at 6.2%, approximately what is 1 month's interest? Option A, $8,010. Option B, $921. Option C, $1,391. Option D, $53,200. The correct answer is option C, $1,391. Monthly interest is calculated by multiplying the loan balance by the annual rate and dividing by 12. Points, tax proration, and front foot value use different formulas and bases. Interest calculations test careful conversion from annual to monthly rates. Question 92. A lot has 180 front feet worth $120 per front foot. What is the indicated front foot value? Option A, $1,999. Option B, $24,031. Option C, $618,750. Option D, $21,600. The correct answer is option D, $21,600. Front foot valuation multiplies frontage by the price per front foot. Tax proration, commission, and income capitalization rely on other formulas. The question asks only for the land value indicated by frontage. Question 93. A buyer's lender evaluates income, credit, and property value without discrimination. Which law commonly governs equal access to credit for Taylor and Moorhead involving a fourplex priced at $310,500? Option A, Equal Credit Opportunity Act. Option B, Statute of Frauds. Option C, Truth in Zoning Act. Option D, Rule against perpetuities only. The correct answer is option A, Equal Credit Opportunity Act. The Equal Credit Opportunity Act prohibits discrimination in credit transactions based on protected characteristics. The statute of frauds concerns enforceability of certain contracts, and zoning or perpetuity concepts are unrelated to lending equality. Financing decisions must focus on lawful underwriting factors. Question 94. Which ownership estate gives Reese Garcia the greatest bundle of rights with no stated end date or condition? Option A, Estate at Sufferance. Option B, Fee Simple Absolute. Option C, Life Estate. Option D, License. The correct answer is option B, Fee Simple Absolute. Fee Simple Absolute is the broadest ownership estate and can continue indefinitely. A life estate ends with a measuring life, an estate at sufferance arises from holdover possession, and a license is permission rather than an estate. The key phrase is ownership without a stated end date or condition. Question 95. A licensee in Egan wants to know which required continuing education topics must be included in the renewal cycle along with the general module. Option A, only appraisal theory and mortgage underwriting. Option B, only property insurance and income tax preparation. Option C, agency law and fair housing. Option D, Only construction codes and zoning administration. The correct answer is option C, agency law and fair housing. Minnesota renewal requirements include agency representation and disclosure training and fair housing training as part of the required education mix. Appraisal, insurance, tax, construction, and zoning topics may be useful, but they do not replace those mandated topics. The rule is designed to keep licensees current on representation and anti-discrimination duties. Question 96. A Northfield buyer's loan has small monthly payments but one large final payment. What is that final payment called? Option A, proration credit. Option B, replacement reserve. Option C, equity dividend. Option D, a balloon payment. The correct answer is option D, balloon payment. A balloon payment is a large unpaid balance due at the end of a loan term. A proration credit divides expenses at closing, a replacement reserve funds future repairs, and an equity dividend is an investment return measure. The structure described is a financing feature. Question 97. A buyer pays 3% in discount points on a $260,625 loan. Approximately how much are the points? Option A, $7,819. Option B, $1,357. Option C, $86,875. Option D, $17,375. The correct answer is option A, $7,819. One discount point equals 1% of the loan amount, so the points are calculated by multiplying the loan amount by the point percentage. Monthly interest, down payment, and commission are calculated from different formulas. The point charge is a loan cost calculation, not a sales commission or equity contribution. Question 98. At closing, a seller debit for unpaid property taxes usually means what for Finley and Bloomington involving a farm parcel priced at $463,500? Option A. The buyer is paying the seller's commission twice. Option B. The seller is being charged for the portion owed for the seller's period of ownership. Option C. The lender has forgiven the loan. Option D. The deed has failed to convey title. The correct answer is option B. The seller is being charged for the portion owed for the seller's period of ownership. A seller debit reduces the seller's proceeds for an amount the seller owes, such as the seller's share of property taxes. It does not double a commission, forgive a loan, or prove the deed failed. Debits and credits allocate amounts between the parties. Question 99. A social media ad for a single-family home in Mankato uses a team name. What must the advertisement clearly and conspicuously display? Option A. Only the salesperson's nickname. Option B. Only the property street address. Option C. The real estate brokerage name. Option D. Only the team logo without the brokerage. The correct answer is option C. The real estate brokerage name. Minnesota advertising rules require the brokerage name to be clearly and conspicuously displayed. A team name may be used only with broker authorization and the brokerage name still must appear. Nicknames, street addresses, and logos do not replace the required brokerage identification. Question 100. Two investors own a Woodbury duplex with unequal shares and no survivorship language. Which ownership form is most likely? Option A, tenancy by the entirety. Option B, severalty. Option C, life tenancy only. Option D, tenancy in common. The correct answer is option D, tenancy in common. Tenancy in common allows unequal ownership shares and has no automatic right of survivorship. Severalty means one owner, and a life tenancy is measured by a life. Tenancy by the entirety is a special marital form not described by unequal investor shares.